If you've just joined us, thank you so much for choosing us over the rest. Channel Africa, where we bring you that African perspective. Let's get into our very first conversation. Today, our guest is Sibongile Ndashe, formidable feminist lawyer and the executive director of the Initiative of Strategic Litigation in Africa, a Pan-African organization she founded in 2014 to transform how strategic litigation is used to advance justice on the continent. Today, we see that ISLA is shaping gender and sexuality jurisprudence within African human rights systems, nurturing a new generation of feminist litigators and supporting social movements to use the law strategically to hold states accountable, particularly in matters of gender-based violence. Today, she joins us from Kenya at a critical movement for the continent as governments make commitments from the African Union Convention on Ending Violence Against Women and Girls. And we're going to be speaking to exactly that. Sibongile, thank you so much for making time for us. Welcome to African Diaries.
Thank you for having me.
Now, you've spent your career confronting the gap between law and lived reality. When it comes to GBV in Africa, how wide is the gap today?
We are struggling. I think there is a gap. We thought that at the very least what we hear in movements is that in Africa we've got good laws. The problem is implementation. And unfortunately now we are also regressing on the laws, which is consistent with what's happening globally. You know, the dismantling of accountability mechanism, weakening of all the systems that we knew and understood as crucial and capable of protecting democracy and our rights. So we are not doing well at this time.
I think what we have seen is that the African Union formally adopted the Convention on Ending Violence Against Women and Girls in February 2025. Have we seen some level of impact with this adoption?
So this convention has not entered force. What usually happens is a convention needs to be signed and then ratified by member states. And when the requisite number of signatures and ratifications has been obtained, then that's when it enters force. This one has not received the minimum, which is 15 ratifications. And we are thankful that that has not happened.
Why are we thankful?
Because it's an awful convention. We have never seen anything like this in the history of treaties from the African Union.
Sure.
The African Union has been developing legal instruments since it was founded. You know, we have the African Charter on Human and People's Rights. And now we have got this convention, which was initiated by President Cyril Ramaphosa when he was chairperson of the African Union. And when his term ended, then it was handed over to other governments. So the Congo was involved and Senegal. And there were conversations at the men's conferences on positive masculinities. But what happens afterwards is something that's a break with tradition of how treaties are usually developed. Normally, a treaty takes years to negotiate, you know, clarifying language, consulting with people, and all of that. The African Union adopted a resolution in 2023 saying to member states, you need to go and negotiate this treaty. The draft did not come until September of 2024. And what happened then, it's something that anyone who has written a law anywhere before has never actually witnessed. I mean, the only time I think when we can have anything close to that was when we had COVID, you know, when regulations needed to come out.
Yeah.
But here we are talking about a continental treaty on ending violence against women and girls. Can you believe that in mid-September, we had a draft sitting at 156 pages, which was decimated to about 98 pages about 2 weeks later. And then we have it at 48 pages sometime in October. And then in the beginning of December, that's when governments now start negotiating. This thing is dropped to 48 pages, 19 pages, 18 pages, 19, and it goes to draft, like 8 drafts. On the 22nd of December, they have what they call the final draft at 11 pages. So there is no consultation. What they refer to as consultation was surveys before the first draft came. You can imagine a continent as big as ours. If a draft is being radically changed, almost every other week, why would you get the time to actually consult, right, on this draft? So we have something that looks nothing like what you would expect of a human rights instrument, a treaty. Because the reason why we have treaties, is to set binding legal obligations for member states. So what we mean here is that a treaty is primarily a legal instrument. So we develop this treaty first to address specific human rights concerns by providing the substantive rights related to those concerns. So here is a treaty which is supposed to tell us that we have a right to be free from violence, whether it emanates from public or private sources. And then from there, it sets out clear state obligations related to those rights. If we are saying we have a right to be protected from tech-facilitated GBV, all of these things that we are seeing in relation to grok, undressing women and all of that, then what we need to see in an instrument like that, it's that we are saying member states must regulate big tech, for instance, or prohibit these new forms, emerging forms of violence like cyber stalking, the impersonations, and all of these things that we are seeing happening with this technology that we have.
Sibongile, I'm going to need you to hold that thought. We do need to take a quick breather. The Executive Director of Initiative for Strategic Litigation in Africa, Sibongile Ndashe.
Africa Speaks on African Diaries with Sheila Ndikumana.
We're still in conversation with Sibongile Ndashe, who is an executive director for the Initiative for Strategic Litigation in Africa. And we are looking at the African Union Convention on Ending Violence Against Women and Girls. Currently in Kenya, she is now addressing the realities of the treaty that moved from 156 pages to an 18-pager that doesn't seem to cover the full view of what the continent needs. Sibongile, I want to talk about this 18-pager for a second here. Does it address the full needs of the continent in context?
No, actually, it's now at 11 pages. So what was adopted in February of 2025 has been reduced to 11 pages. So what happens in human rights treaties, so some of the things, because there are people who are still supporting this treaty, sadly, it's that this treaty mentions cyberspace, right? Cyberspace is a zone, right? When we're talking about all of this kind of digital, like stuff and all of that. But when we talk about violence against women, we really have developed standards that talk about tech-facilitated gender-based violence and femicide. We're not just talking about cyberspace as a zone. We are saying that there are these emerging forms of violence that we need to be protected from. The problem with the convention is that it does not understand this. For them, cyberspace just appear haphazardly in this 11-page document as just a zone or as a space, but not as a new or emerging form of violence that requires critical legal attention where you need to set out state obligation. This continues to happen. For example, another thing that we have been talking about in the past few decades, it's something like femicide. Even when it comes to femicide, it doesn't set out, obligations to prevent femicide, because we understand the causes of femicide and the consequences. And over time, there have been people working to develop standards. So what happens in this kind of editing and development is that there were quite a lot of things that were lost, right, in this convention. So right now, what we are sitting with is a document that is actually quite shambolic, to use that word, because it does not use any of the frameworks that we understand, legally, that this is what you use to combat violence. So, for example, way back in 1992, there was an agreement, to call this gender-based violence because it is overwhelmingly gender-specific in that it targets women more than men. And that when you look at the things that are responsible, I usually make an example that it was important to define this gender-based violence because it was trying to surface that this violence happens because it is normalized, legitimized, and justified. So we continue to see when women are subjected to domestic violence that the question is asked, what did she do? We still young women getting killed, like 2 bodies lying on the streets in Pretoria towards the end of last year. And people immediately went and blamed them, that they were out there, drinking this man's money and refusing to put up at the end of the evening, something which was not even true. But you find that there are people who have got these ready-made defenses for this type of violence. These aren't things that happen ordinarily. If a man were to be killed, at a club, these ready-made answers that justifies this violence would not be there. And so part of it was to show that discrimination is the reason why this happens, because it's about autonomy over women's body. It's about women being treated as second-class citizens, so that when you are in a relationship or you are married, then there's something, that you actually owe the other party. So you can't come home late, or even if you come home late, then it is justified, that you can be beaten up. Something that's not justified for anyone else. Like, people will not do that to their friends. People will not do that to their colleagues. But because this violence happens in the private sector, it happens to women generally, then that's why it was important to say we need to prevent this violence by recognizing that discrimination was at the heart of it. Yeah. This convention doesn't go anywhere near that, to foreground this on these frameworks that we understand. So, for example, years after this discrimination framework, or actually it was around the same time, there was something that we were given, as people who work in protection of human rights, something called due diligence. Due diligence in violence against women or gender-based violence, it's that the state can be held accountable, if it acts in such a way that perpetrators are not held, accountable. So these are all the frameworks that we know. So when you go to this convention and you look at Section 5, Article 5, that deals with state obligations, these state obligations, the way we know, the way we speak about state obligations, are not there. What it does, it goes and gets like a subset of something, that looks like you recognize it, but it's actually something that would typically sit in a policy framework, or in a different duty. But you do not find what one expects to find in state obligations. State obligations, we know them, they are known globally. Is that they have the obligation to protect us from violence, to respect our rights, to fulfill, the rights that are there. But when it comes to violence, it's you protect, and when you protect, there's you have to investigate, prosecute, and punish. That's what happens in protection in the criminal justice system. So that's how, as litigators, you expect to find rights in a legal instrument, because it makes it clear to member states that this is what you have to do in order to protect people from violence. It messes up definitions that we have had over time, like women's rights defenders. We understand the violence that women's human rights defenders are subjected to. They start by a definition that says a woman's right defender is a national, which means that people like me who cross borders and leave South Africa and I'm in Kenya, I don't have protection as a women's human rights defender when I'm in Kenya, because this convention says the rights belong to nations only. This is serious regression, right? But even when it comes to what are the state obligations, their understanding of women's human rights defenders are basically service providers, people who are working with governments, to implement GBV projects. But most of the time when we talk about violations of women's human rights defenders, these are the women who have been killed, right? As they were defending, women's human rights. We've seen this with women working in environmental justice. We have seen this with women working in different kind of industries. And this is it's conceptually weak, but it actually is a convention that doesn't know what it is doing. There are things, there's so many things. There are only 11 substantive sections, starting from Article 2, kind of ending at 14, 13. There isn't one provision here that is salvageable. And that's the thing that makes these things scary, because promoters of this convention say this convention talks about cyberspace. And the question is, what about cyberspace when you haven't set out state obligations to protect women in cyberspace? They say it mentions femicide. Yes, it does mention femicide, but it doesn't mention it in a way that femicide should be mentioned in a legal instrument, in that it has to set out state obligation and establish norms and standards for addressing these specific human rights concerns with regard to the state obligations, Yeah. And this, we ensure that these norms and standards that are created have the effect of respecting, protecting, promoting, and fulfilling the rights, that are protected in the framework. So it's a very scary thing, because most of the time when you talk to people who have looked at this convention, they say, yes, I've heard about it. And some organizations have already started pushing for ratification. When you sit down, with them, they said, I'm not a lawyer. I don't necessarily know how a legal instrument needs to be, in order to be effective. And so that's when you have to say, this is what a convention does. This is what a treaty should have. Even the structure of this document is insane. A treaty typically has got 3 sections. You have the preamble, you have the substantive articles where the rights are articulated, and then you've got the operational provisions. You go to Article 4, you find objectives. The objectives of the treaty should not be in the substantive articles. The objectives should be in the preamble. You go to Article 6, it speaks to guiding principles. Guiding principles should not be in the substantive part of the convention. It has to be in the preamble. So it looks like a bad first-year law school assignment. That's what we are dealing with.
Sibongile, just to interject there, we are time pressed, unfortunately. I want to address the reality that we have different contexts across the 55 states, 56 arguably, across Africa. I mean, you think of countries that allow child marriage. You think of countries that have laws that stipulate that your body is no longer yours once you get into a marriage context. And so with those different definitions of the framework of law and constitution in the country, is it even plausible for Africa to come together and create such a document, such a treaty?
So I'm happy that you mentioned child marriage, because this is supposed to be an African instrument. So one of the things that you would expect is that it addresses the most prevalent forms, of violence. We've got early child marriage, we've got FGM. All of those things are not even mentioned in this convention.
Sure.
Right? And that is why our responsibility right now is to tell the African Union in Addis to recall this convention and actually adopt a resolution to recall this convention and revise it, because we cannot afford to have a legal instrument that looks like this. Because legal instruments like treaties are not without consequences. They don't come every year, every decade, or every day. Globally, there are 2 regional violence against women treaties. The Americans in the Inter-American were the first to do that in that system, and then the Europeans were the second ones to do that. We are the third ones, and ours has to be the most progressive because it's actually responding to the context, that we are living in now. The others don't have the things, that have been developed as part of the response. And so we can't afford to have a treaty that can't even sit in a timeline, where you look at it and it's like, oh, maybe this was developed 20 years ago. It doesn't actually look like this because it is nonsensical.
Sure. Sibongile, I think we will cap it there for now. Thank you so much for giving us your time, and I can only hope that we'll see a better light ahead of us, yeah?
We hope so too, because this is scary.
Sure. The voice there of Sibongile Ndashe, Executive Director of the Initiative for Strategic Litigation in Africa, currently in Kenya attending the convention, the African Union Convention on Ending Violence Against Women and Girls. However, the context in which this treaty is being formed is so diverse in nature. Just looking at the various constitutions of various countries that allow child marriages, that have laws that speak to how a woman is not of ownership of her own body in the context of a marriage, I think is one to consider when thinking about this treaty coming together as a collective. Started off as 156 pages, is now at 11 pages and does not address the reality of the African continent as stated by Sibongile Ndashe. It is a few minutes before the top of the second hour.